Mr. Blazer, and Mr. Cochran. People represented by Mr. Darden and Mr. Goldberg. The jury is not present. Counsel, late yesterday afternoon, I received a package of test materials from the LAPD SID lab, some new lab notes or whatever that I've copied. And Mr. Goldberg, Mr. Scheck, if you'll approach, I'll give you each a copy of these. One for you, and one for you. Good morning. All right, counsel, anything else we need to discuss before we invite the jurors to join us?
Yes, one brief application, Your Honor, that I filed a letter with the court yesterday and counsel about the production of handwritten notes of witness statements, and I was informed by Mr. Darden and had an opportunity briefly to speak with Mr. Douglas, and I was told that there had been an agreement that, as a general matter, handwritten notes from either side of witnesses were not required to be produced. But as I indicate in my letter, however, I have one particular concern that I think goes beyond just the general agreement, and that is I'm concerned that with respect to the communications between Ms. Clark and Mr. Fung with respect to this visit to the Bronco on July 6th, because I think the state of the testimony is that he's testified that she sent him to look for red stains on the Bronco on July 6th.
The question is, are there any notes in existence
Yes.
regarding
and,
that?
And if there, and some representation with respect to when it was that he reported to her, if that happened, and
I thought we covered this already.
I'm talking about from the prosecution. In other words, I know what the witnesses said, and the witness's testimony, I think, is contradicted, and there's a contradictory statement to the investigator from the LA Police Commission. All that I'm saying is that I think that there is an obligation to correct a testimony or to reveal impeaching testimony, and I don't want to be in a position where they've looked at their notes or they thought about what it is and they've made some decision that they really don't have to reveal it. I think that this is a sufficiently troubling area that we ought to have something stated on the record so we know what the prosecution's position is.
Mr. Darden?
Your Honor, we are well aware of our responsibilities under Brady with regard to impeachment material. And as for the agreement between Ms. Clark and Mr. Cochran and Mr. Shapiro regarding attorney's notes, there have been many occasions during the trial when we would have liked to have had defense counsel's notes. We have lived up to our obligations under that agreement, and this is an issue I thought that we were going to discuss this afternoon with Mr. Cochran. That is the issue regarding our prior agreement that attorney's notes will not be discoverable in this case.
All right, well, my inquiry is simply this, counsel. Are there any notes or reports regarding the visit to the Bronco by Mr. Fung at the request of Ms. Clark during the preliminary hearing, roughly July 6 or 7-ish?
Okay.
That's the only question that I have.
Okay. I am not aware of any notes, but still, we do have an agreement here. I expect defense counsel
Well, I understand
to live up to
that. No,
agreement.
my only, I'm not asking for district attorney notes regarding interviews of witnesses or anything of that nature at this point. I'm just asking, are there any reports generated by Mr. Fung or any written materials regarding that?
Analyzed evidence report, which has already been introduced. We know of no others, but we
All right.
will check.
I'll accept that representation.
Your Honor, my application is putting aside notes. And I realize Ms. Clark isn't here, so maybe we should just, move on and we could take it up at a break, although I would like to finish with this witness, and I know the court does.
No, we are going to finish today.
I know.
All
Hopefully
right, well,
this
then
morning.
let's proceed. When Ms. Clark arrives at the first morning break, we'll inquire of her, and we'll do it that way. All right, let's have the jurors, please.
Just one other matter.
Hold on.
The court probably doesn't want to take this up right now, but counsel has been asking me about the order of witnesses, and I've been trying to tell them. They seem to ask me almost every day. But one of the hitches is we have the issue as to the scope of Mr. Yamauchi's testimony, and we've tried to resolve it informally and not been able to. And we could significantly change our strategy in terms of how we're going to put on the scientific portion of the case, depending on the resolution of that issue. I brought it up earlier, but at some point that should be resolved.
All right, so who's next?
Well, next is going to be criminalist and Zola. So I know that. And following them will probably be the truck driver, Mr. Wilson, the photographer. But at that point, that is the point at which we would reach Mr. Yamauchi, and from that point forward, I can't say until that issue is resolved.
All right. Well, I see us not getting to those issues for perhaps the rest of the week. All right. All right, let's have the jury, please. The witness stand. Mr. Dennis Fung is on the witness stand undergoing recross-examination by Mr. Scheck. Good morning, Mr. Fung.
Good morning.
You're reminded you're still under oath, sir. And Mr. Scheck, you may conclude your recross-examination.
Thank you, Your Honor. Good morning, ladies and gentlemen of the jury. Good morning, Mr. Fung. How are you, sir?
Good morning.
Mr. Fung, let's turn to the question of the socks that Mr. Goldberg asked you about on redirect examination. Now, is one of the habits you have when you testify to use a selective memory?
No.
Do you have a habit of being vague when you think it's going to help the prosecution's case?
No.
Do you have a habit of being specific when you think it's going to help the prosecution's case?
I answered the questions to the best of my ability.
Now, you testified yesterday, you were asked, did you do any close visual examination of the socks when you picked them up? And you answered, no, not a close one. Recall that.
Yes.
Now, you have a specific recollection that you did not look very carefully at those socks.
I did not look at those socks for blood because they were dark. And, I mean, a specific laboratory type analysis was not done at that scene for the presence of blood.
My question to you is a simple one, sir. Do you have in your mind a specific recollection that you did not perform a careful visual examination of those socks?
Yes.
Now, you went there looking for, on Rockingham on the afternoon of June 13th, you were looking for bloody clothes.
Yes.
And the socks, you say, were out of place.
Yes, they were.
And you were concerned, were you not, that they might have been socks worn by the assailant. That was the prosecution's theory.
That was a possibility.
I object to that. I don't think we really
Overruled.
That was a possibility.
And do you think, sir, that it would be very helpful to the prosecution's position for you to remember a careful visual examination of the socks.
Speculation, sustained.
Now, you were asked some questions on redirect examination about the timing of your collection of the sock.
Yes.
And you were asked by Mr. Goldberg, question, now when you were at the Rockingham location, you saw a pair of socks in the master bedroom. Answer, yes. Question, and can you tell us whether you collected those between the collection of item 12 and item 14 by looking at your crime scene identification checklist? Excuse me. Answer, it was collected within that time frame. I don't know if it was collected in between those two times, though. Question, what are the two time frames? What is the time frame for 12? Answer, the time frame is 4:30. Question, and that was the stain in the foyer? Answer, yes. Question, and what time is it? What is the time for 14? Answer, the time for 14 is 4:40. Question, and that was the stain in the master bathroom? Answer, yes. And then a little later, Mr. Goldberg came back to this, and he asked you question. Now, I just want to make sure I understand your testimony. Do you know whether you collected 13, that's the socks, right?
Yes.
In between 12 and 14? Answer, I know it was in that time frame, but I don't specifically recall, nor can I tell from my notes if it were. Question, for sure? Answer, for sure. Question, but it was in that general time frame. Answer, yes. Remember being asked those questions and giving those answers.
Yes.
Now, have you, that was different, was it not, than your testimony on direct and cross-examination?
Sustained.
On direct examination,
Page, line. Maybe Mr. Blazier can do a word search.
That's exactly what we do. These computers, you print them out and sometimes you don't get the exact page.
Is there something else we can move on to when Mr. Blazier?
No, I think
comes back?
actually it 21575, line 9. Ready?
Mr. Goldberg.
Line 18 through.
I think 24. Question by Mr. Goldberg. All right, Now, after collecting item number 12, did you go upstairs in the location? Answer, yes, I did. Question, do you recall what was the next item of evidence you collected? Answer, the next item was a pair of socks in the master bedroom. We asked those questions, did you give those answers on direct?
Yes.
Now, on cross-examination, 22-302.
Mr. Scheck, which line? Which line?
Starting at 22-302 at line 4. May I proceed?
Oh, man, line 4 through line 26.
Proceed.
Question. And then the next item was a red stain from the foyer area inside Rockingham, correct? Answer, yes. Question, and that one was collected at 4:30. Answer, yes. And or thereabouts. Question, or thereabouts. And the next item you collected were the socks. Answer, yes. But there's no time indicated for that. Answer, that's correct. And the next item after that you indicated was a red stain that was found in the master bathroom. Answer, yes. And that time is at 4:40. Answer, yes. So I believe it was your testimony on direct examination that you collected the socks sometime between 4:30 and 4:40. Answer, about then, yes. Were you asked those questions and did you give those answers?
Yes.
Now, Mr. Fung, hasn't it come to your attention that there is a video that was taken on the afternoon of June 13th of the interior of Rockingham by a photographer from SID?
Yes.
Vaguest time when it came.
Overruled.
Have you been informed that on that video there is a shot of the master bedroom?
Yes.
Have you been informed that on the camera there is a time of when the video is being shot?
I believe there was a time present.
So you've seen that tape?
Yes.
Your Honor, I would ask that we be permitted to show a segment from that tape.
I didn't hear what you just said.
I'd like to show a segment from that tape, and I'll show it to counsel.
What's the evidence number on this one?
It's 1068.
Your Honor, may we approach for a moment?
For what purpose? It's a defense exhibit already marked, 1068.
Yes, I realize that, but counsel did not give us advance notice that they wanted to do this. And there is, I'm not objecting necessarily to playing the tape, but there is one portion of it in terms of the time.
I'll show him.
I'd like to discuss that sidebar.
As to the accuracy of the time,
Right. I don't know if the time code is on this or not.
Mr. Scheck, does 1068 have the time code on it?
Okay, then we need to approach.
All right, with the record reporter, please. One attorney from each side. Thank you, counsel. Proceed.
Mr. Fung, you told us that you've seen the tape.
Yes, or portions of it.
And in this tape, you recall seeing that there is a panning shot of the bedroom area and the bed.
It's vague as to what panning shot means and what area specifically.
Overruled. Do you understand the question?
Yes.
And at the point the camera passes over the carpet area and the bed and cuts just at the moment that one would have seen an item in the position of the socks as they were photographed on June 13th.
Is that a question?
Yeah. Is that what you saw on the tape?
There was a panning shot, but I don't believe from the angle that the shot was taken that the socks would have been visible.
When you saw that tape, did you see that at the point that the socks should have appeared, the tape cuts?
Well, it's still vague.
Ask me what he saw. Goes to
Overruled.
his state of mind.
Well, I remember looking for the socks in the videotape, and they weren't there
And,
in the video.
all right. And in your, now you prepared for this redirect examination over the weekend?
I came in over the weekend, yes.
How many days?
Let's see, Saturday, and then I viewed a videotape on Sunday.
What about Friday afternoon?
That's not the weekend.
I understand, that's why I asked the question.
No, not on Friday afternoon.
And was it over the weekend that you saw this videotape?
Well, it's vague as to which video.
The videotape of the interior of Rockingham?
I did not view the videotape of Rockingham that day.
When did you view the videotape of Rockingham?
It was the day after, to the best of my recollection, it was the day after the hearing for the videotape with the photographers and the detectives were.
So you were aware,
Perhaps we could at some point get the court to take judicial notice about it.
I don't recall myself when the date was.
I don't either, but
All right, Mrs. Robertson will give that to us shortly.
have you
Proceed.
spoken to any of the people at SID who testified at that hearing about the videotape?
In what regard?
Well, have you spoken to a Mr. Atkins
I have spoken to Mr. Atkins,
about the videotape?
just that he was going to have to testify because it was taken.
And was there discussion between the two of you about a time on the videotape that would indicate when that videotape was taken of objects in Mr. Simpson's master bedroom?
N-
hearsay, Your Honor.
Overruled. Was there a discussion of that, yes or no?
No.
And what about with a gentleman named Ford?
Yes.
And do you know if he testified at the hearing?
I believe he did.
And did you have a discussion with him about the time on the videotape where it depicts items in Mr. Simpson's master bedroom?
No.
In your preparations for redirect examination with the prosecutors, did you have a discussion with them about the times on the videotape which shows items in Mr. Simpson's master bedroom?
I believe the subject came up.
And when the subject came up, did they press you to change your testimony that the collection of the socks happened between 4:30 and 4:40?
No.
Did they press you to say that your collection of the socks was not necessarily after item number 12 and before item number 14.
No.
In other words, your testimony on redirect examination that you're no longer sure if the socks were collected between 4:30 and 4:40 was just something that you decided to say on redirect examination without any consideration of the time on that videotape.
This argument that
Oh, well.
My testimony then was, and still is to the best of my memory.
Is that your answer?
Yes, it is.
Well, isn't there a difference between the way you testified about the time in which the socks were collected and the order in which the socks were collected on redirect examination versus your direct examination and cross-examination?
calls for speculation, compound.
Sustained.
Well, you had read to you questions and answers of what you said on direct,
Yes.
and you had questions and answers of what you said on cross-examination about this.
During some portion, yes.
I just did that with you now, right?
Yes.
And then on your redirect examination, do you not concede, sir, that your testimony changed?
Argument calls for speculation.
Oh, well.
I answered the question with different words, yes.
Well, the different words that you used were a change in when the time, withdrawn. The words that you used constituted a change in the time that you could have collected the socks.
I understand that mistakes the evidence. There was no change in time.
Sustained. Rephrase the question.
When you answered on redirect, you were now saying that you did not know if the socks were collected in between 4:30 and 4:40, right?
Mistakes the testimony.
Sustained.
Were you asked, question, and can you tell us whether those between the collection of item 12 and item 14, by looking at your crime scene checklist, answer it was collected within that time frame. I don't know if it was collected in between those two times, though. Question, what are the two time frames? What is the time frame for 12? Answer, the time frame is 4:30. Question, and that was the stain in the foyer. Answer, yes. Question, and what is the time for 14? Answer, the time for 14 is 4:40. And that was the stain in the master bedroom? Yes. Question. Now, I just want to make sure I understood your testimony. Do you know whether you collected 13 in between 12 and 14? Answer. I know it was in that time frame, but I do not specifically recall, nor can I tell from my notes if they were. Question. For sure. Answer. For sure. We asked those questions. Did you give those answers?
That was asked and answered.
Overruled. You can answer the question.
I was asked those questions.
Now, you don't think that that's different than your direct testimony?
Argument.
Sustained.
Mr. Fung, is this a habit you have of suddenly becoming vague if you think it's going to help the prosecution's position?
Sustained.
Now, you were asked some questions on redirect examination about the videos of Bundy and a three-dimensional brown object on the blanket. You recall that?
I never. I don't recall it being a three-dimensional, saying it was three-dimensional. There was a dark object on the walkway area.
And Now, you spent a lot of time going over those videotapes with the prosecutors, haven't you?
I spent some time looking at the videotapes and going over still photographs.
How much time?
All about a half hour, an hour, maybe.
That's all?
That's all.
From the time you first saw those videotapes to the time you came in here and testified about it on redirect examination, you only reviewed those for a half hour?
Well, it's vague as to which video.
He said half hour to an hour is what he said.
Half hour to an hour.
It's still vague as to which video.
Overruled.
You can answer.
Yes.
Now, I think you testified on redirect examination that when you looked at the video and the stills, you were going through a process of reconstruction.
Yes.
And you had no independent memory, withdrawn. And part of that, and in your reconstruction of the stills and the videotape, you had a very specific recollection of putting down a card near a pole at a certain point in time.
Well, it's vague and unintelligible as phrased to them.
Overruled.
They're stuck with the tape or...
Overruled.
I had a recollection of putting a card down by the pole.
Yeah.
I don't think that's a recollection. That's something that I saw happen in the videotape.
All right. So in other words, you had no independent memory of exactly what you did in putting down the cards. You just looked at the videotape and looked at still photographs and sort of made up what you think happened.
Sustained.
You looked at the still photographs and you looked at the videotape and you tried to reconstruct what you think happened.
I looked at the videotape, I looked at still photos, and with what I remember from the crime scene, I came up with a reconstruction.
Well, your memory of the crime scene, did it include exactly what cards you put down next to the objects and in what order you did them?
It's overbroad as to cause.
Sustained.
Did you have an independent recollection of which cards you put down at what time?
It's still vague as to place.
Sustained.
As to any of the cards that you put down
At Bundy.
at Bundy with respect to the glove, the hat, and the envelope, did you have a specific recollection of what you did and when you did it?
I don't have specific recollection as to what exact time it is, but I do know what order I did things in.
Well, when you put the cards down, do you have an independent recollection as to whether or not you put a card down in one location and then, before the photographer took a picture, decided to move it to a somewhat different place?
Seems facts not in evidence.
Sustained. Rephrase the question.
At any time when you were putting down the cards near the hat, the glove, and the envelope, do you have a specific recollection about putting down a card and just leaving it in the first place you put it?
No.
Could you have put down a card and then decided to move it a little bit?
That's a possibility.
And isn't it true, sir, that the reconstruction that you went through of the still photographs and the videotape are based on the assumption that you put certain cards down, left them in positions, and didn't change them, and you did it in a certain order?
My reconstruction is based on that, plus the fact that I would not move the evidence until a photograph had been taken.
Have a specific recollection, withdrawn. Could it have been, sir, that when you were putting down a card by the hat, that you put it down at one place at first and then moved it to another?
Your Honor, impulse respect.
Sustained. Which phrase?
Well, based on your recollection of the crime scene, is that something that you could have done?
It's still impulse respect.
Sustained.
Two photographs that I'd like to have marked as defendants next in order. One would be then, one 1108 and the next one 1109. And I'd like to put 1108 on the elbow.
All right.
Your Honor, I'd like to object to showing these photographs of actual footage.
What's the basis, legal basis?
The legal basis is it's not impeaching, therefore not relevant.
Overruled.
Mr. Fung, I'd like to direct your attention to the envelope. See that?
Yes.
Do you see where the card is behind the envelope?
Yes, I do.
And that's an envelope, that would be number 104, which would be the photo ID of the envelope. Why don't you check it?
May the record reflect that he's checking what appears to be his crime scene identification checklist.
Yes.
Yes.
Are you checking a page that indicates the time in which these objects were collected?
No.
Because you didn't write down in your evidence item collection sheet the time that these items were collected.
The Times were not written down at Bundy.
So when you went through this reconstruction with the still photographs and the videotapes, you didn't even have the times that the items were collected.
It's argumentative. That's
Sustained.
Now, has to show the next item.
All right, 1109.
You recognize that to be a picture of the envelope again?
Yes.
And that's card 104,
Yes.
and that's in a different position in that photograph.
But the envelope is in the same position.
The envelope is safe, but the card is in a different position.
That's argumentative.
Sustained.
It's not an,
Is the card in a different position?
Asked and answered.
Overruled.
yes, the card is in a different position, but that's not uncommon for the card to be moved in a different position when, for photographic purposes.
Right. It's not uncommon at all to be moving these cards around during the process of still photography.
That's correct.
But your entire reconstruction, without independent recollection, based on the videotape and the still photographs, is based on a very specific judgment about which cards were placed down in what order.
It's unintelligible and overbroad.
Overruled.
My reconstruction was based on those factors plus my practice of not moving evidence
So
until photographs are taken.
So the basic assumption here is that you don't move evidence before it's photographed.
That is my general practice.
Well, that's what you did here,
That's what I did here.
and it would be your general practice to report if someone moved evidence from the position in which it was originally found to a different position.
It's overbroad.
Overruled. This is something we've already
I'm
gone
moving into it right now. You were asked questions on redirect examination about why you thought the scene might have been altered.
I don't specifically recall that line of questioning.
Do you recall questions on redirect examination about your responsibility to find out who might have altered the crime scene?
In redirect,
Yes.
Your Honor, his ability to recall testimony is irrelevant.
Overruled.
Were you asked these questions, and did you give these answers on redirect examination?
Sustained.
Well, Your Honor, we don't have page citations.
You need to give page citations. If you can't give page citations, you can't do it.
Well, we don't have. All right, we have a page number from yesterday's transcript. We have live notes. I have the questions and answers.
Check with court reporter. Do you have something else you can move on to?
No.
How much more do you have?
Like an hour.
Let me check and see on the availability of our daily transcript. Yes, that's true. We have a photocopy repair person since 8:30 this morning working on our machine.
Your Honor, if it would be,
Do we have a master copy that's available? All right, Ms. Olson, would you check on that, please? Apparently Ms. Moxham stepped away. All right, ladies and gentlemen of the jury, if you want to stand and stretch for a moment, I'm going to have the court reporter get the transcript from yesterday. I'm going to recess at this point.
well,
I mean, we're within
It's a
15.
problem. It's just I can get these on the computer, I can get right to the page, but without the transcript page number, we can't, it's quite a bit. If you want to take it, it's going to take you 3-4 minutes. It's up to you.
All right, let's do this. Ladies and gentlemen, we're going to take a 15-minute recess at this point. Please remember all my admonitions. Do not discuss this case amongst yourselves. Don't form any opinions. Don't conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. We'll stand in recess for 15 minutes. All right, thank you.
Asking me for page numbers.
My mistake. All right, let's have the jurors, please.
Your Honor, on this, I do have an objection. It's not inconsistent. I don't know whether you want to handle
Well,
this.
tell me what it is. Read it for me. Hold on to the jury. Read it for me.
You want me to?
Read it for me.
All right,
I didn't know who the-
I have,
Apologize.
Your Honor,
I believe
You're
he
making the
was.
objection, counsel. Read it for me.
Okay. Did you know whether the crime scene had been altered before you arrived? Answer. I assumed it had because the body of Nicole Brown Simpson was on the plastic when I walked up to the scene. Answer. Okay. And you assume that when she was murdered, it wasn't on that coroner's plastic bag? Answer. Yes. Question. Now, was it your job as a criminalist to start interviewing witnesses for the purposes of determining what the crime scene was like when they arrived? Answer, no. Question, whose job is that?
The detectives.
Answer, that is the investigating officer's job, the detectives.
Mr. Goldberg anticipates me. I think the correct form for recross-examination is I must direct the witness's attention to the questions he was asked on redirect in order to set up impeachment with prior testimony, which is exactly what I'm going to do with this first set of questions. And in fact, I think the witness was actually a little vague on the issue of altered, but that's all I'm doing with these questions. I think it's my responsibility
This
to
is your
direct them.
foundation to set up an impeachment?
Yes.
All right, and what's the second passage?
Well, Your Honor, can Mr. Fund step out then if I'm going to do all this?
No, are you making a good faith offer that you've got it there?
Yes, I've got an impeachment from prior
All
testimony.
right, let's
I think
proceed. Let's have the jury,
proceed.
please.
And that's that if there are two separate passages that are inconsistent, it's not relevant. That can be argued to the jury, but there's no need to ask the witness about it.
Overruled. Reflect, we've been rejoined by all the members of our jury panel. Mr. Scheck, you may continue.
Thank you very much, Your Honor. When we left Mr. Fung, I had asked you if you recall testifying on redirect examination about realizing the crime scene had been altered before you arrived. And Mr. Goldberg, page 23066, starting at line 11. On redirect examination, where you ask, question, did you know whether the crime scene had been altered before you arrived? Answer, I assumed it has because the body Nicole Brown Simpson was on the plastic when I walked up to the scene. question, okay, and you assume that when she was murdered, she wasn't on the coroner's plastic bag. Answer, yes. You recall that?
Yes.
All right. Now, when you got to the crime scene and you saw Mr. Goldman's body removed, didn't you think that might have altered the crime scene?
That is changing the crime scene, yes.
Well, Mr. Goldman's body was removed from the caged-in dirt area and dragged across the location where the envelope, glove, and hat was.
Sustained.
Were you concerned that when Mr. Goldman's body was removed, it could have been dragged across the area where the glove, the hat, and the envelope were found?
Beyond the scope of my
Overruled.
I was not in the immediate area when Mr. Goldman's body was moved.
Well, when you say immediate, you were standing in the bushes near the walkway area, weren't you?
I don't believe so.
Well, do you recall a videotape of you stepping over the body holding what you've told us was the Rockingham glove with your bare hand in a bag?
Yes.
Well, are you telling us that you were not in the area when Mr. Goldman's body was removed from the caged-in area and put in front of the steps on the walkway?
That was after he had been moved.
Okay. Well, you knew his body was in the dirt caged-in area.
calls for hearsay speculation.
Overruled.
Yes.
And you knew that it had been removed to the front of the steps.
Yes.
And did that cause you any concern that the removal of his body from the caged-in area to the front of the steps might have caused the glove, the hat, and the envelope to have been moved?
It's irrelevant as to his concern.
Overruled. You can answer the question.
It did not occur to me at that time.
Did you ever bother to ask anyone about it?
This is beyond the scope of we went into this extensively.
Overruled.
Did I ask anybody about it? I don't recall asking anybody about it.
Did you ever compare your measurements of where various objects were with the measurements taken by Detective Lang?
Seems facts not beyond the scope of his cases.
Overruled.
I have never compared my measurements with Detective Lang's measurements.
Now, you have testified, for after looking at the videotapes and the still photography and reconstruction, that the Bundy glove was ever in a third position on the blanket.
Could you repeat that?
Sure. Do you remember during cross-examination we talked about position 1, position 2, and position 3?
Yes.
All right. And position 3 was that object on the videotape, which you're saying is not the glove, right?
Yes.
All right. If that were the glove, that would be a third position.
Argumentative.
Sustained.
You do concede, however, from looking at still photographs, that the glove had been moved from a position where it was originally photographed when Detective Furman was pointing at it to a second position when you directed the photographer to photograph it.
Argumentative.
Overruled.
Yes.
Okay? So you concede there are at least two positions for the glove.
That's been answered argumentative.
Overruled.
There are two positions that I know of.
And there are two positions for the envelope.
Yes.
Now, you learned about this 2 months ago when you were listening to the radio and heard in the crime scene laboratory and heard testimony?
This is vague and compound.
Sustain, rephrase the question.
When was the first time you learned that the envelope had been moved?
I don't specifically recall knowing that the envelope had been moved. I know that there was testimony that evidence that the Bundy crime scene had been moved prior to my arrival.
Well,
or prior to my collection process.
I'm now on April 11th at page 22123,
Certainly.
starting at line 20. Starting at line 20. Question. When,
Yes. Proceed.
question. When did you first learn that the envelope had been moved from its original condition as it was found at the crime scene? Answer, the first I heard about it was during the trial. Question, when? Answer, this trial. Question, when during the trial? We have been here for a while. Answer, you're right, when Detective Lang was giving testimony. Question, about a month ago, 2 months ago. Answer, whenever he was giving testimony. Question, and isn't it your responsibility? Well, how did you learn about that? Did you speak to Detective Lang? Answer, how did I learn of it? Question, yeah, that the envelope had been moved. Answer, I overheard it on the radio. We asked those questions, did you give those answers?
Yes.
Now, you're under instructions to avoid, if you possibly can, listening to any testimony.
That misstates the court's orders as expert witnesses.
Sustain.
Do you regard yourself as under any restriction in terms of listening to or watching any testimony of the trial?
It's irrelevant.
Sustain.
Have you listened to testimony of the trial?
Listen to some portions.
Have you watched any of the testimony of the trial of prior witnesses?
Yes, I have.
How much?
It's vague as to which witnesses.
Which witnesses?
Oh.
I've seen portions of Detective Lang's testimony, Detective Van Adder's testimony, Detective Furman's, some of Mr. Kalin's.
And you paid careful attention when... Are you finished?
And just various other witnesses.
Mhm.
I've seen parts of all of them.
And have you paid careful attention when Detective Lang and Van Adder and Furman testified about anything that might involve your activities?
I never get a chance to sit down and concentrate on it, but if I hear my name, it piques my attention.
And when you were observing their testimony, did you get a pretty good idea of what attacks were being made on their credibility by the defense?
Sustained.
Did you form any ideas in your mind as to what attacks were being made on the credibility of Detective Lang, Detective Van Atter, or Detective Furman by the defense?
Sustained.
Did you form any opinion in your mind as to what kinds of attacks were being made on the credibility of Detective Furman?
Overruled.
It seemed to me that his overall credibility was being questioned.
Did you pay attention to any specific areas of testimony?
All right, this is becoming irrelevant.
All right. Now, returning now to the glove in position 1 and position 2. So you recall learning for the first time about position 1 and position 2 during Detective Lang's testimony.
Overruled.
Yes.
Now, on redirect examination, Mr. Goldberg asked you about your obligations to interview witnesses at the scene to find out what it was like before you arrived. Recall that?
Yes.
Counsel, page 23066, again at line 20. Question.
Is this from yesterday's?
Yes. Reading from before.
Which line, counsel?
23066, line 20. Question. Now, is it your job as a criminalist to start interviewing witnesses for the purposes of determining what the crime scene was like when they arrived? Answer, no. Question, whose job is that? Answer, that is the investigating officer's job, the detectives. Were you asked that question, did you give that answer yesterday on redirect?
Yes.
Now, isn't it true that you just gave that answer because the prosecution wanted you to say it, even though you knew it isn't, you know it's not true?
It isn't my job to interview witnesses.
Do you have a habit, sir, of when you testify, of going along with whatever suggestions the prosecution makes to you?
Sustained.
Page 22145. You recall answering questions?
Wait.
I understand. I'm just asking a prefatory question while he's getting the page.
Proceed.
Do you recall answering questions on this very same issue with respect to your responsibility to investigate whether evidence has been moved or altered on cross-examination?
22145.
Yeah.
What line, counsel?
4.
I don't know that. I know it's definitely.
Line 4.
All right, with the court reporter, please. All right. Thank you, counsel. Proceed.
Mr. Fung, were you asked these questions and did you give these answers? Question. Now, Mr. Fung, isn't it your responsibility to investigate whether evidence at the crime scene has been moved or altered from its original position? Answer. In some respects, it is my responsibility, yes. Question. All right. And are you supposed to make inquiries of people at the scene as to whether or not evidence has been moved or altered? Answer. Yes. Were you asked that question, those questions, and did you give that answer on cross-examination?
Yes, I did.
But when Mr. Goldberg asked you questions on redirect yesterday, you said that it is not your job to interview witnesses for purposes of determining what the crime scene was like when they arrived. You said that was the detective's job.
Overruled.
That's what I stated.
Well, Mr. Fung, is this a change in your testimony now, your position on redirect?
Mr. Goldberg asked about witnesses, which is different from the question that you asked.
Let me read again from line 12. Question. Are you supposed to make inquiries of people at the scene as to whether or not evidence has been moved or altered? Answer, yes. You make a distinction in your mind between witnesses and people?
Witnesses would not include the investigating officer, or the detective, in my mind.
Would it include the representatives from the coroner's office?
I think it's vague as to what he's referring to.
Overruled.
I really haven't given it that much thought.
Would it include the people from SID Print Division?
I wouldn't consider them witnesses, no.
Would it include the photographers from SID?
I wouldn't consider them witnesses either.
Well, other than the detectives, the photographers from SID, the coroner's representative, and the print people, the representatives from the print unit at SID, was there anyone else at the scene who could have been a witness?
Calls for speculation, it's irrelevant.
As phrased.
To your knowledge, was there any other person that could have been a witness other than the detectives, the representatives from SID, and the photographers?
It's calls for speculation, and it's
Overruled.
irrelevant.
Overruled.
There were a lot of people at the scene, but not in the scene, who could be considered witnesses.
Well, the people, the other people you're talking about were being kept away by that yellow crime scene tape.
And officers.
In terms of figuring out whether what the crime scene was like before you arrived, weren't the only people you could possibly interview as witnesses those officials who were allowed inside the yellow tape?
I don't consider detectives and people working in the police department as witnesses.
Mr. Fung, this distinction you're making between people and witnesses, isn't it just an effort by you to avoid admitting that on redirect examination you said exactly the opposite of what you said on cross-examination?
Sustained. Sustained. Sustained.
Now, in terms of your responsibilities, putting on the relevant section from the crime scene checklist.
Is this the one with the question mark in the box?
Yes. The crime scene checklist, that's where you directed Ms. Mazzola to put a question mark.
I didn't direct her to put a question mark there, but one was put there.
I'm sure you didn't previously testify that you directed her to put a question mark there because you realized when you got to the scene that you saw Ms. Nicole Brown Simpson's body on plastic.
I may have.
Okay.
What exhibit is this, Mr. Harris?
All right, this is that group of documents, the number of which escapes me that...
All right, this is page,
But thank you, Ms. Goldberg.
I can't see the page number on the
It's
top.
page 2.
All right, page 2.
Now, this box says, has the scene been altered? If so, by whom and how?
Yes.
And isn't it your job to find out if the scene had been altered, and if so, by whom and how?
It's still overbroad.
Overruled.
In some respects, it is.
And you have known now, since you heard Detective Lang testify, that the glove and the envelope were in two different positions.
Asked and answered.
Overruled.
I know that some evidence had been moved.
Well, you know, you have agreed, have you not, that the glove and the envelope were in two different positions.
Yes.
To your knowledge, sir, since you have discovered this, have you conducted any investigation as to who might have put the glove and the envelope back into a second position?
I have not conducted an investigation, no.
To your knowledge, has anyone conducted such an investigation?
Wait a minute, that seems taxed on this motion to strike.
Overruled.
The question is answered.
Overruled.
Please repeat the question.
To your knowledge, has anyone conducted such an investigation?
Calls for speculation.
Overruled. To your knowledge, do you know if anybody has? Yes or no?
No.
Proceed.
Would a failure to find that out constitute, in your mind, a cover-up?
Your Honor, that's argument.
Sustained.
You told us about your definition of covering up.
Yes.
As far as you're concerned, would a failure to learn who it was that moved the glove and the envelope constitute a cover-up?
Argument, Your Honor.
Sustained.
Mr. Goldberg read you a section from the book by Dr. DeForest, Dr. Ganslin, and Dr. Lee, Forensic Science and Introduction to Criminalistics. You recall that?
Yes.
That was at the end of your testimony on redirect?
Yes.
All right, and direct your attention to page 415 onto 416. And you recall he read...
Certainly.
You recall he read you a passage concerning that it is probable no crime scene has ever been processed in such a way that hindsight would not allow someone else to criticize the work at a later date.
Yes.
He read that sentence to you. Let me read you the next few sentences and tell me if you agree with them. However, investigators must learn from their mistakes and must strive for continuous improvement. No attempt should be made to cover up these mistakes or offer excuses for them. Responsibility for mistakes should be faced squarely. You agree with that?
Yes.
Have you done that in this case?
No.
Well, today this is done what? Cover up or not cover up?
It's the same. The answer's stricken. It's vague. Do you want to re-ask the question?
Sure. Have you made an attempt to cover up mistakes or offer excuses for them?
No.
Have you met your responsibility to face mistakes squarely?
I believe I have.
And as far as you're concerned, if you had any knowledge whatsoever as to who moved the glove in the envelope, you would have no hesitation to come forward and tell us.
I would not. If I had knowledge of it, I would have no hesitation, no.
Now, let us turn, sir, to the videotapes that we saw in redirect examination of you and Miss Mazzola entering and leaving the Rockingham location on the afternoon of June 13th. Now, prior to testifying at all at this trial, had you seen a video of yourself and Miss Mazzola when you leave Rockingham and put the valise and the paper bags into the rear of the crime scene truck?
Prior to...
Prior to beginning your testimony at this trial, did you see that segment?
I've seen it, yes.
And when you testified initially, you said that you carried the blood sample out in either a paper bag, a posse box, or by itself in your hand, but you thought that last possibility was unlikely.
Yes.
And part of that testimony, I take it, was based on reconstructing from the first videotape that you saw before you testified.
When I gave that testimony there,
Yeah.
I didn't take that into consideration. I was just naming possible modes of transporting that envelope from my memory.
Now, on April 14th, that's before we saw the KABC videotape, you were asked some questions on this issue by Mr. Goldberg on redirect examination. You recall that?
Yes.
All right, and I'm at 22898, line 14.
Question.
And at that point in time, did you have an independent recollection, meaning from your own memory, of what happened on the 13th as to exactly what receptacle, if any, you put the blood vial envelope in? Answer, no, I did not. Question, now these are by Mr. Goldberg. Question, Mr. Fung, where did you come up with these different possibilities? Answer, those were packaging items that are in the crime scene, available in the crime scene kit, and I name those types of packaging or packages. Question, okay, but did you have any memory at that time of putting it in a brown paper bag as opposed to the posse box, as opposed to just handling it without putting it in anything? Answer, no.
That's
Okay.
correct.
Now, when you're answering those questions, you were saying you were not sure of the container or receptacle. Is that right?
Yes.
Overruled.
But you never doubted the fact that you were the one that carried it out.
No.
Then,
Overruled.
now you recall, withdrawn. Before you testified in front of the jury on cross-examination with respect to videotapes of you and Miss Mazzola coming in and out of Rockingham, we showed you some tapes outside the presence of the jury.
Yes.
And I showed you a tape, two segments of Detective Van Adder getting out of his car, carrying a folder with something on the outside of that folder.
Yes.
And when I showed you these tapes, at some point I called your attention to the fact that between the trip where you went to the car and put the bags in the truck, all right, and the so-called plastic bag trip, Detective Van Adder's car was in the second set of footage, but not the first.
Yes.
And when you saw that, that's when you realized that the blood sample couldn't be in the paper bag, the posse box, or that you could have carried it out yourself.
This was all asked for us.
Overruled. You can answer the question.
It wasn't at that point that I realized it.
Well, it was when you were watching these videotapes that you realized it?
No. It was sometime in the morning when I woke up that had occurred to me.
Well, the afternoon before you woke up, you had seen some videotapes of yourself and Miss Mazzola leaving?
Yes.
All right. So your memory in this morning when it came to you was jogged by your viewing of the videotape.
Well, it's vague as to whether it's a memory or a reconstruction.
Overruled.
Well, I started thinking about it more and more and more, and things started coming back.
Well, on redirect examination, did you not testify that you still have no independent recollection of placing the blood sample envelope in a trash bag?
That's correct, and I still don't.
Right. And you testified on redirect examination yesterday that it's possible other things that you collected that afternoon could have accounted for the heft inside that plastic bag.
Overruled.
I don't know if I stated that or not.
I'm at page 22971 to 22972. I'm going to read to line 4 of 22-972.
No, it has to be on all the way down to line 24, everything in context on page 22 on 72.
Just,
With the court reporter. Thank you, counsel. Proceed.
question, Mr. Fung, do you have an independent recollection as you sit here today of placing the item that you received from Detective Van Adder, the envelope, into a plastic bag? Answer, not an independent recollection, no. Question, okay. And when you looked at the scene of Andrea Mazzola taking the plastic bag out of the location, was there anything that you collected between 5 o'clock and when you left with Andrea Mazzola that could have accounted for the heft in that bag other than the envelope? Answer, possibly. But it is most likely that the envelope was in that bag.
Yes.
Okay. Now,
Mr. Goldberg? These have two photographs that I've shown the prosecution that I'd like to mark defendants next in order. We have them. 1110 and 1111.
We have them in barcoded so that I can show them the picture and then Mr. Harris can swipe the barcode and put it up on the screen.
All right.
Now, Mr. Fung, do you recognize that photo to be a shot of the valise, the kind of valise you use when you go to a crime scene?
I'm sorry, what was this one? This one, I missed that.
10, oh, excuse me, 1110.
That is one type that is used.
Is that the type that you carried on that day?
And I really don't recall.
Well, how many of these valises are there at SID? About 4, right?
There's this type, and then there's other types that don't have this specific configuration.
But in terms of, putting aside the configuration, in terms of the types of things that are in it, do you recognize on the left-hand side those cards that you put down next to items for purposes of photographing?
There's several different makeups of crime scene kits. These, as long as all the items are, those types of items are in there, it's okay, but there's no one specific place for any one thing.
Not talking about the place where everything is, I'm talking about the items within the kit.
This is typical of what would be included in a kit.
And so one of the things that you carry within the kit are these card markers.
That is an item, yes.
All right. And you, when you went back and used at the crime scene, of various envelopes, such as depicted in this photograph,
Yes.
of various sizes.
Yes.
And now, this depicts some of the water bottles and packages that you use to, which contain swabs, correct?
This is typical of that
Right.
type of thing, yes.
Well, call your attention to those packages with the swabs. That's the kind you use at the lab.
Yes.
Now, okay. Now, when you went back into the house, do you recall if you put the cards in an envelope of some kind?
Let's fade as to which time.
When you went back in the second time, and you were picking up the cards, do you recall if you put anything like that in an envelope?
I don't know what I did with those cards. I may have thrown them away.
Did you retrieve any packages of materials that you might have left from your work at the crime scene?
I don't recall if I did or not.
Well, you recall, Withborn, you've testified that after you got the envelope from Detective Van Adder, you asked somebody to get you a trash bag.
I asked somebody to get me a bag so that I wouldn't have to carry the envelope out in plain view of the media.
Oh. And you were given a trash bag.
And I was given a trash bag, yes.
And the picture that we saw on the KABC tape shows you in the foyer with a trash bag in your hand and something that appears to be in the shape of an envelope.
Well, that was there.
Overall, yes.
Now, after you got the envelope containing Mr. Simpson's blood sample from Detective Van Adder, you said you opened up the envelope and inspected the vial.
Yes.
be marked defendants next in order.
Do you want to show that to Mr. Goldberg? All right, that'll be 11:12. Mrs. Robertson, 11:12? 11:12. You may.
And Mr. Fung, does this appear to be a test tube of the same size and configuration as the one you inspected on the afternoon of June 13th?
To the best of my recollection, yes.
And on the morning of June 14th, you also handled the blood vial.
I handled the envelope, but I don't know if I handled the blood vial itself.
This is testimony at the preliminary hearing at page 78.
Yeah, what lines from what lines?
Page 78 at line 26.
This is inconsistent.
Refreshing the witness's recollection.
It's not how to do it then.
All right. Let me, may I approach?
You may.
Let me show you this document for a minute, Mr. Fung. Direct your attention. Starting here.
Okay.
Now, having read that, is your recollection refreshed that you handed the blood sample to Mr. Yamauchi on the morning of the 14th?
The vial and the envelope were given to Mr. Yamauchi.
And do you recall, and was the vial pretty much full?
It's beyond the scope of the direct, it's not, redirect, it's not impeachment.
Sustained.
Well, Mr. Yamauchi, could you mark for
Fung.
us
Mr. Fung.
on, what number is this, Your Honor?
Mr.
Sorry.
Fung.
My apologies. Mr. Fung, could you mark for us on this test tube, which is defendant's
11:12.
1112, where the blood was up to in this test tube when you inspected it on June 13th?
I couldn't do that.
Well, Your Honor, I make a motion to strike, 'cause this is beyond the scope of the...
Sustained.
Well, you examined the test tube that you got from Detective Van Adder
On the 13th.
on the 13th. Did it appear to you to be pretty much full?
Beyond the scope.
Sustained.
When you saw the blood vial on the morning of June 14th,
Was it pretty much full?
Assumes effect on evidence and...
Sustained. With court order. All right, thank you, counsel. Proceed.
So, it's your testimony that you can't tell us, sir,
Your Honor, I object to continuing to pursue...
Sustain.
I just want to ask this one question, Your Honor, about his
I
recollection.
sustain the scope objection, counsel.
Now, when you were in the foyer area during this period, you saw a number of detectives come in.
I saw detectives come in, yes.
Detective Furman,
I don't recall.
you saw Detective Furman coming in wearing a coat.
Rephrase the question.
When you were in the foyer area on your second trip, you saw Detective Furman walk into the...
Based on videotape?
Yes.
Yes.
No, I make a motion to strike just based on the...
Call roll.
Now, you testified on redirect examination on the 14th that, I'm at 22925, line 18.
To what? 19 to what?
Just question and answer.
Just what?
Just the question and answer.
Well, this is the impeachment.
No, I'm just calling his attention to his testimony.
Proceed.
Were you asked by Mr. Goldberg, recall being asked by Mr. Goldberg, question, did you ever say anything, make a point to say anything about the vial? This is to Andrea Mazzola. Answer, no. Question, did you have any reason to? Answer, no.
That's correct.
Now, you're saying that you had no reason to tell Andrea Mazzola anything about receiving the blood vial?
Not making specific mention of it. No.
She was keeping the notes on inventorying objects, items that you received?
Yes.
Did you regard the blood sample of the defendant as an important piece of evidence?
Most for speculation is important.
Call roll.
It was a piece of evidence.
You didn't regard it as a particularly important piece of evidence.
That's vague. Particularly important.
Did you regard it as an important piece of evidence?
And at that,
Counsel, it's not a necessary question at this
All right.
point.
Was there any other piece of evidence that you collected that you didn't mention to Andrea Mazzola on June 13th?
Call roll.
I don't recall any.
After you received the blood vial, were you concerned that it get back to the laboratory in good shape?
Yes.
Now, when you didn't have anything in your hands when you walked out the second time from Rockingham.
In the second videotape, no.
You could have carried it.
Yes.
And the vial is breakable, isn't it?
Yes,
If it broke, it could have spilled, blood could have spilled and been potentially dangerous to your health.
potentially.
And you saw in the videotape where Ms. Mazzola is carrying that plastic bag, and it's swinging and hitting shrubs and other things as she's walking to the truck.
Sustains.
Now, did you have a reason to keep this a secret from her?
Sustained.
Is there a reason that you did not tell her that you were putting a blood vial in a trash bag for her to carry out of the residence?
No,
Is it the custom and practice at LAPD to give important fragile items of evidence to criminalists in trash bags and not tell them what they're carrying?
Sustained.
Is it your custom and practice to give fragile items of evidence to criminalists in trash bags and not tell them what they are carrying?
Sustained. Sustained. No. Sit down. Proceed.
Now, was there a reason that you did not? The envelope says refrigerate on it, doesn't it?
yes, it does.
But it's your testimony that you now have an independent recollection that you took the plastic bag containing the envelope and put it on just left it on a table in the evidence processing room.
Sustained.
How many other times in your career, sir, have you collected items that are supposed to be refrigerated and just left them on tables overnight in plastic bags?
I don't have any specific recollection to that.
Now, you recall during cross-examination that you saw a videotape of your bare hand grasping a paper object.
Yes,
And it's still your position that that was not the envelope containing prescription glasses?
yes, it is.
I'm sorry?
That's my
That's-
position.
That's your position. And you did not notice that segment of the videotape before you testified at trial in the tapes that you were reviewing?
I didn't make any particular notice of it.
So, when you were asked whether or not you had grasped the envelope in your bare hand on cross-examination, you said it didn't happen.
Sustained. Rephrase the question.
Is are you saying that's a pad, not the envelope?
Sustained. Rephrase
Is
the
it your
question.
position now, sir, that what's depicted in that videotape is not the envelope but a pad?
Sustained.
What is it?
I don't know what it is, but it's not the envelope containing those glasses. It
And-
may be a bag, it may be another packaging material from the crime scene kit.
And after you saw that videotape of your hand on the item, you said, after examining it carefully, that you were even more sure in your mind that it is not the envelope because we did not start picking up evidence until well after the coroners were gone.
Sustained.
Your Honor, he asked questions about the coroners on redirect
Sustained.
examination. Now, after you saw videotape showing the coroners present at the scene when Miss Mazzola was picking up the hat and the glove, you realized that you could not claim that it wasn't the envelope based on the fact that the coroners weren't there.
Overruled on that basis. Overruled. Argumentative it is. Sustained.
you were shown a segment of videotape which depicted the coroners being present when Ms. Mazzola was collecting the hat and the glove. Your Honor, he asked several questions about this.
Overruled. Quickly.
Trying.
Yes, I did see videotape of that.
And when you saw that videotape, withdrawn. Now, on redirect examination, I'm at page 23045. Did you...
Yes.
23045, counsel.
Now, on redirect examination, we asked these questions, and did you give these answers? Question. Calling his attention to his testimony. Question. When you were involved in the collection process, were you trying to keep track of where the coroner's representatives were, or if they were even there? Answer, no. Question. To this day, do you have an independent recollection of them being there? Answer, no independent recollection, no. Question. Do you have any reason to believe that they were there other than the one clip of videotape that you saw with what appears to be the pants leg of one of the coroner's representatives in it? Answer, no. Only the videotape shows that they're there. Court giving that answer?
Yes.
So you're now saying, sir, that you're sure that that isn't the envelope.
Yes.
And you're sure because it is not your practice to touch objects with your bare hand.
Overruled.
Not my practice to touch bloody items that could be for prints.
So your certainty with respect to the envelope comes from assuming that you always follow the rules.
Sustained.
Is it your habit when testifying, sir, to say that you use correct procedures even if you do not have an independent recollection of what you did?
I testify to what I can remember, and if I don't have a specific memory, I will state that I don't and testify to what I generally do.
And sometimes you testify to what you generally do without saying, this is what I generally do. You just state it as a fact that you did it.
Sustained.
I have the envelope that is item number 10. Now, you recall on direct examination a videotape of you stuffing the blue gauze pad back in the envelope. Redirect, I'm sorry.
Yes.
All right. Your Honor, could we have a knife again?
A knife?
Knife, your pen knife, scissors, anything.
Not.
Oh, things are getting more ominous as... Could you please cut the top of the envelope, the same fashion that we did before?
Along the bottom again?
Just along that.
Well, I'll object because if it's the same fashion. I think he was wearing gloves and everything too, so.
Yes, that's true.
Mrs. Robertson? Gloves?
Would you please unseal the top and drop the item on the stand,
Okay, counter.
counter, the witness stand.
For the record, you just cut along the top.
Just put it as you got it. Now, when you first took it out, it was wrinkled, wasn't it?
Yes, it was.
All right. And it was wrinkled because when you stuffed it into the coin envelope using the scoop method, it became wrinkled in that fashion.
Yes.
Right? But when you first saw that item, when we pulled it out originally, it was just folded over.
Oh, wait a minute, that's irrelevant how it was when you first saw it.
Overruled.
It was just folded over, wasn't it?
That's because other people had analyzed it since.
I'm only asking you what you, when you first saw the
wait.
item.
One person talks at a time here. If I have to instruct another person as to that rule, there'll be sanctions. Thank you. Proceed.
May I make an objection?
Yes, you may.
I object that he allowed the
Basis.
witness to answer, to finish his answer.
Proceed.
Finish with your answer?
Yes.
When you first saw that blue item, it was folded.
Yes.
It wasn't wrinkled.
Do you mean, did it have any wrinkles in it, or?
Yes, was it wrinkled in the same fashion as we saw it when you put it on the table just now?
Wait. Was this piece of evidence analyzed for anything?
Yes.
Your Honor,
Really? This is...
Your Honor.
The jury saw it when it came out, the jury saw it when it went back in. Proceed.
next question, Your Honor. Would you agree that this item became wrinkled by the method you used to insert it into this coin envelope? The scoop method.
Calls for speculation.
Overruled.
Yes. It was wrinkled by that method.
All right. But when you first took that item out, I showed it to you on cross-examination, it was not wrinkled in that fashion through the scoop method, was it?
It was,
Irrelevant.
Overruled.
it was folded.
It was folded. Your Honor, I'm finished with that.
All right. Mr. Fung, would you return that, please? All right. Mr. Fung has placed it back into the envelope. Proceed.
Now, when you, on redirect examination, tried scooping it into the envelope, you were trying to do something clever to avoid the inference that Detective Furman had collected that item with gloves on the morning of June 13th.
Sustain its argumentative.
Did you have any concern when you were testifying with respect to this item that the jury might believe that Detective Furman had gloves in his possession on the morning of June 13th when he collected that item?
Argumentative.
Overruled.
No.
Let's turn to the Bronco, sir. Show you what's been the People's 197B. Now, this is the photograph you were shown on redirect examination.
Yes, it was.
And this is a photograph taken on June 14th.
Yes, it is.
Are these 4 reddish stains a quarter of an inch long?
From the best of my recollection, no, they're not.
Are these reddish stains that look like brush marks?
They don't appear to be brush marks to me.
When you observed these items on the door sill of the Bronco on June 14th, were they red?
They were reddish.
Sure then.
Yes.
Do they appear to you to be reddish in this photograph?
When I look at the monitor, in this picture right now, I can't even see the stains.
All right, we've changed the contrast on it.
No.
Well, now they appear dark.
Not red.
Well, Your Honor, this isn't the photograph that you were showing.
No.
Overruled.
It's in evidence.
Have you examined the photograph?
Yes.
Does it look red in the photograph?
It looks brown or dark in the photograph.
Gray or black?
It's dark.
Specks of dirt?
It's not a question.
It's a stain.
Could it be specks of dirt?
Speculation.
It's vague as to what we're talking about.
Now, on July 6th, Ms. Clark told you to go out and look at the Bronco, you're testifying, to see if there were 4 red stains on the exterior of the door sill?
She told me to do that at some date prior to that. I don't know. I don't believe it was on the 6th, but I did go out there on the 6th to look for stains that were visible from the exterior,
Well,
specifically on the driver door.
didn't she tell you to go out and look at the exterior of the driver door the day before you testified at the preliminary hearing?
It was around that time, but I'm not absolutely sure that it was the day before. It may have been 2 or 3 days before.
Have you previously testified that you went out to inspect the Bronco the morning of your testimony of the preliminary hearing, which was July 6th,
Yes.
and that you had been told to go out the day before to do it?
Well, transcript page.
Try it this way. Were you informed by Ms. Clark that a detective had testified to seeing red stains on the door sill of the Bronco?
She had told me that a detective had told her that stains were visible from the outside of the Bronco.
4 red stains on the exterior of the door sill.
She didn't tell me how many.
Well, cross-examination, page 22410, line 22.
Certainly.
Six next.
I'm sorry.
I'm sorry, and keep the book there, please, because we're going to go to another page.
Maybe you need lines.
Well, I'm starting at 22410, line 22. Ready? Question.
Your Honor, I'm going to encroach an objection on this.
Is this foundational?
No, this is,
All right, let me see what the court report is.
it's got 2 purposes.
All right, thank you, counsel. Proceed.
In this photograph, which is People's 197B, you identified 4 items.
Yes.
Now, on cross-examination, on page 22406, line 1. We asked these questions, did you give these answers?
Hold on. Proceed.
Question. My question, sir, is it your testimony that you saw 4 red stains on the exterior of the Bronco door on June 14th, but you thought they were not heavy enough, and therefore you did not direct the photographer to take a picture? Is that what happened? Answer, I can't. I don't know if there were 4 or not. The number 4 is the problem with the answer. Question, you saw 3 on the exterior of the Bronco on June? Answer, I don't recall the number. Question, are you saying that you saw 3 red stains on the morning of June 14th? Stains. On the morning of June 14th? Answer, no, I'm not saying that. Are you saying you saw 2 red stains? Answer, I do remember that there was either a stain or 2 stains that were very light along the sill area that I did not collect. Ask those questions, did you give those answers?
Yes.
Now, after the weekend, and looking at photographs, you're now prepared to say that 197B shows 4 red stains that you saw on the morning of June 14th.
Those are areas that were present that I don't specifically remember these stains, but I do remember stains present on the vehicle in those locations approximately, and these are consistent with those areas.
Well, you're telling us that you have an independent recollection of seeing 4 stains on June 14th?
No, it's not what I'm saying.
You're not saying that.
I'm not saying that.
So basically, what you're telling us is that you looked at this photograph, and you're now reconstructing the fact that those must be 4 red stains.
I knew that I remember seeing stains on the door sill that day, and looking at the photograph, I'm identifying these as possible red stains.
Now, 3 of the items that you've circled here can only be seen if the door is open.
The 2, the very top one and the one to the right, that's correct.
So to see these items, someone would have to open the door of the car.
To see those, yes.
Now, you gave us testimony that the fibers from a carpet can get into the crevices of shoes.
They have a more, yes.
And so, if someone has stepped in blood and the shoes are no longer making impressions of bloody shoe prints on cement, when a person steps on fibers, the fibers will go into the crevices of the shoe.
It's possible.
And that would be true for the shoes of a police officer who had stepped in blood, as it would be for any other person wearing shoes.
Overruled.
If that was, yeah, it is likely.
Now, the mat in the car, the Bronco, doesn't have fibers,
No,
and the brake pedal doesn't have fibers.
it's made out of rubber.
Now, you told us that you didn't swatch these items, these red well, you didn't, withdrawn. You did not swatch the items that you saw on the door sill
That's correct.
on June 14th,
Yes,
because you were only taking representative samples.
I was taking representative samples.
Where is it in the rules of your laboratory that there's a doctrine about taking only representative samples?
I don't know if it's written anywhere, but that's the way I was trained, and that's been the policy handed down and taught to every criminalist that's worked for the Los Angeles Police Department.
Is there any document that you know of in the crime lab that talks about taking only representative samples?
I'm not aware of one.
And in terms of swatching a stain so that you only get a representative sample, is that in any document in the crime lab?
I don't know of any document to that effect.
And we're clear on this. You recall testifying that when you swatched stains in the Bronco, you didn't swatch the whole stain, you only swatched a representative sample of the stain.
I believe that wasn't for every stain, but one stain in particular that you were talking about.
Stains on the console.
Yes.
But as far as you know, the only document in the crime lab that instructs you about swatching for purposes of DNA testing directs the criminalist to get as much of the stain as possible.
Oh. The collection for conventional serological or conventional serology and DNA collection are essentially the same.
Do you recall, withdrawn, haven't you seen a handout that gives directions on how criminalists should swatch blood evidence?
If you could show it to me, I may be refreshed, but
Do you recall you and I went through a form that had about 13 different directions on them?
you've shown a lot of things to me over the last 8 days.
Okay. Now, on redirect examination, you indicated that you didn't think that you were necessarily covered by the rules in the Los Angeles Police Department manual.
I believe
Let's do it this way. Do you believe that you're covered by the rules in the Los Angeles Police Department manual?
certain aspects of the manual do pertain to the civilians, yes.
The manual, as it sets forth rules on the booking and handling of evidence, does that govern you?
Haven't we gone over this already?
Well, he did it on redirect. I'm doing it fast.
Doesn't mean we have to do it again.
Well, I'll do it fast. I have just 2 or 3 questions here.
The guidelines and the general principles are applicable to us, yes.
Well, there are guidelines and general principles, but you don't feel that you have to follow those rules as written with respect to booking evidence?
As long as I'm following the intention of the policy, that's what the manual's for.
And the rules say that you should book biological evidence as soon as possible?
Yes,
And in this case, you did not book by putting the items into the evidence processing, the evidence control unit, the swatches from Bundy, or Mr. Simpson's blood sample, or the glove, or the hat, or any of these items until June 16th.
Beyond the scope of the redirect unit.
Overruled.
booking those items of evidence by June 16th was very quick.
My question, sir, you did not take them to the ECU and have them stamped and booked until June 16th.
That is correct.
Now, you've told us on redirect examination that no rule or procedure would be violated if you had told Andrea Mazzola to throw out some original pages of the crime scene checklist and write a new form.
Well, it's overbroad. You can specify certain images.
Overruled.
I stated that they could be rewritten.
Well, weren't you asked that there was no rule or procedure that would be violated if you had told Mr. Zola to throw out the original page and write a new form?
Still take this first page.
Overruled.
I stated something to that effect about a portion of a form, yes.
Well, it was the page where Ms. Mazzola had written, Ms. Mazzola had written in handwriting, right, 17 as the sneakers, 18 as the blood vial, and 19 as a hair from the Rockingham glove.
The one with no actual form writing on it or
Yes.
Xeroxing?
But it was on the back of a piece of paper that was an official form.
Yes.
Well, are you telling us that that form could have been, that original piece of paper could have been thrown out without violating any rule?
As long as the information was transposed to another form,
So you feel you have no obligation to save original documents?
Well, it's vague as to time.
It's also irrelevant. It is the document.
In your crime lab, are there any rules that require you to save original crime scene checklists?
It's still be relevant these days. That's all.
All right, he asked questions that you could just throw these out.
Answer the question.
once there are rules, yes.
The rules are that the originals are supposed to be kept in one place in the laboratory.
The final version of the originals, yes.
Now, you were informed that there was a court order to produce original documents in this case.
Eventually, well, one was ordered, yes.
Well, do you recall, when did you first learn that there was a court order to have original documents examined?
It was somewhere around the preliminary hearing. That's what I recall.
Preliminary hearing, that was in July 1994.
That's what I recall. I don't recall when it was.
Somebody asked you in July of 1994 to produce your original documents of the crime scene checklist?
To the best of my recollection. I don't recall exactly when, but that's when I recall.
Who asked you to do that?
I don't know.
Someone in the lab?
I don't recall.
Well, did Michelle Kessler or Greg Matheson review your originals in July?
I don't recall when they reviewed my originals.
Your Honor, I have
Go ahead and finish.
15 minutes.
Go ahead and finish.
With 15 minutes?
Be my guest.
Thank you. Now,
Madam Reporter?
Is that okay? Now, do you recall about 2 months ago that you were informed that the defense had requested the originals of your crime scene checklists for purposes of having them examined by a document examiner?
Yes.
And were you involved in producing the originals for that purpose?
I was involved in some portion of it.
What portion?
There came a question as to, there were some items missing from my set of original notes, and I was asked to look for them, and I did find one page at that time.
This was a page that was undated, that recounted what you had given to Mr. Yamauchi on June 15th?
Yes.
And what happened is that someone came to you from either the lab or the prosecutor's office and said, this page isn't an original. Can you find the original?
Mr. Matheson called me and asked me if I had that page.
And you went through the blue notebook in front of you,
Yes.
and you found the original for that page.
Yes.
Did anyone ask you to go through the other pages that had been produced for the defense document examiner to be sure that you had in fact produced all the originals?
No.
No one made that suggestion to you?
No.
Now, before my cross-examination ended of you, you had a conversation with the prosecutors about page 4 of that checklist.
Before your...
Page 4. Before my
Before it ended?
Yes, just at the time it ended.
Rephrase.
All right. There came a point when I asked you some questions and documents were distributed to the jury.
Yes.
All right. And there was a break and you spoke with prosecutors.
Yes.
And you went through your book.
I'm not sure if I went through the book at that time or at a subsequent break.
Well, before Mr. Goldberg got up and started asking you questions on redirect examination, had you gone through your book and identified at a page that you believed was the original of page 4?
I do remember going through it prior to Mr. Goldberg's redirect.
All right. And was there a conversation with prosecutors about this item that you'd come up with, this page 4?
Yes.
And was a decision made in your presence by the prosecutors?
Sustained. Calls for legal conclusion. Sustained.
Did you, once you identified this page that you realized was the original page 4, say to anyone, oh, there's a mistake, we should have given this document to the defense before?
Sustained.
Just a few questions about the blanket. Maybe one. In your judgment, sir, is the only way to have secondary transfer of hairs, fibers, and cellular material from the blanket that was brought to the Bundy crime scene to waive it?
Hairs, fibers, and cellular material compound.
Overruled.
Is that the only way
Yeah.
for it to transfer?
Yeah.
The most likely way is for it to have transfer through direct contact.
Now, I'm now at 23137, line 16.
Certainly.
page 47,
Line 16.
23, 127.
No, 23, 137.
Through 17.
I just have it here, and I'll just start reading. If you want. Ask this hypothetical question by Mr. Goldberg. Question. All right. Now, if hypothetically there were saliva from the defendant that had been dried on the white blanket, could that saliva somehow float down the entire crime scene and hit the rear gate and turn red? Answer, no. Question. All right. Would you expect that saliva or any biological material would contaminate the stains that you and Miss Mazzola had collected along the trail? Answer, given your hypothetical, no. You were asked those questions, gave those answers.
Not impeaching, so it's irrelevant.
It's foundational.
Yes.
Now, you were shown a photograph of the rear gate at Bundy
Yes.
that was taken on June 13th. Do you have that here?
Let me see if I can find the exhibit number.
While we're looking for it, let me just ask you some questions. You remember seeing that photograph?
Yes.
And there was a blood spot that you saw on July 3rd that was labeled 116.
Yes.
And you did not see that on the photograph, the blown-up photograph that was taken on June 13th.
This is beyond the scope, Your Honor.
Oh,
I did not see it.
And you cannot tell us from your own personal knowledge how 116 got there on July 3rd.
Not from my personal knowledge, no.
But you're certain it was not planted there by anybody.
That calls for speculation, it's argumentative.
sustained.
Are you aware, sir, that 1.9 milliliters, or 1/4 of the blood collected from Mr.
Sustained.
Simpson's blood
Sustained.
unaccounted for?
Assumes facts not in evidence, counsel. Not an appropriate question. The jury is to disregard the implication of that question. Proceed.
Mr. Fung, you've been listening to the testimony at this trial.
Certain portions of it, yes.
You heard the opening statements.
We're not cross-examining on that, counsel.
Well, Your Honor, this is the last line, and if you want, I'll approach on it.
It assumes facts that aren't in evidence, counsel.
I'm not talking about evidence, I'm asking about his awareness of defense positions.
Not as phrased.
All right. Has it come to your attention that the defense alleges
Your Honor, can we approach on this?
Yes, with court order. Proceed.
Do you know a Michael Stevens from the District Attorney's Office?
Overruled.
I know someone named Mike, but I don't know if this is the person you're referring to.
Tall guy with silver hair?
Okay.
Do
I
you
think
know
I
a
who you're talking
Dana
about.
Thompson from the District Attorney's Office?
I've met Dana.
You know Mr. Thompson to be a senior investigator in the District Attorney's Office.
I only know he works for the DA's office.
Has either of these gentlemen ever asked you any questions with respect to the handling of Mr. Simpson's blood vial?
Overruled.
No.
Show you this photograph 166A. Mr. Fung, where's drop 116 that you saw on July 3rd?
I'll check. It's already gone into this.
Overruled.
It does not appear in the picture, however, it may be on the curved area behind it. It just doesn't appear in the picture, though.
And it may be that it got there sometime between June 13th and July 3rd. You can't tell us from your own personal knowledge.
Sustained.
No.
All right. All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember all of my admonitions to you. Do not discuss the case amongst yourselves. Do not form any opinions about the case. Do not conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. We'll stand in recess until 1:30. Mr. Fung, you're ordered to return 1:30. Thank you, Counsel. Mr. Dennis Fung is again on the witness stand. The defense has concluded their recross examination, and Mr. Goldberg, you may redirect.
Good afternoon, Mr. Fung.
Good afternoon.
Ladies and gentlemen. Mr. Fung, do you remember being asked some questions on recross about a videotape that was taken at the time of the search warrant?
Yes.
And did you, in fact, have a chance to view that videotape?
Yes.
And you said that that was when?
I viewed the videotape before I started my testimony here.
Okay, so that videotape couldn't possibly have affected your testimony here, could have it, since you'd already seen it?
Sustained.
Sir,
Rephrase the question.
okay, did you ever consider changing or altering your testimony in any way based upon seeing that videotape?
No.
All right, now, as to stain number 12, the one that was downstairs in the foyer, do you recall, sir, whether you collected the downstairs items in the afternoon of the 13th prior to the upstairs items?
We began downstairs
Okay.
and worked our way upstairs.
So that, in that case, 12 would have been collected before 13?
Yes.
And what time was 12 collected approximately, according to the crime scene identification checklist?
According to the checklist, it was collected at 4:30.
All right. And do you recall my asking you on recross whether you were sure about whether 13 was collected before 14?
Yes.
Are you 100% sure?
Not 100% sure, no.
Which one do you think was collected first?
I think the socks in item 13 were collected first.
Before 14?
Yes.
But you can't be 100% sure?
I'm not 100% sure.
And when was 14, the item in the bathroom, master bathroom, collected, that stain?
That stain was collected around 4:40.
So you're saying, I believe, that the socks were collected after 4:30 well, between 4:30 and 4:40 approximately.
In that general time frame, yes.
And as far as you are concerned, Mr. Fung, does it make the slightest bit of difference that you can figure out when they were collected within that general time frame?
No. Doesn't make any difference to me.
Would it make the slightest bit of difference that you've been able to figure out whether the socks have been collected at 4:38, 4:39, or slightly after 4:40?
No.
Now, when you viewed the videotape that we were discussing, was there in fact a shot that depicted a portion of the patterned, I guess you would call it a throw rug, in the defendant's master bedroom?
Yes.
And did you view that and compare it to still photography?
Yes.
Sir, was the area that the socks were collected from depicted in that scene?
The area where the socks were located was blocked by the bed in the video camera shot.
Was the throw rug a pattern type rug?
Yes, it was.
And did you look at the patterns on it when you did this comparison?
Yes.
Now, sir, you were asked some questions about whether you made any inquiries of people at the scene regarding any alterations of the scene. Is that correct?
Yes.
Are you supposed to make any inquiries of anyone in terms of alterations?
Yes.
Who's that?
The, excuse me, the detective at the scene is who I make inquiries of.
The investigating officer?
Yes.
Do you consider that to be a witness interview?
No.
Are you generally aware that police officers and detectives do witness interviews and sometimes fill out witness interview forms in LAPD?
Brown.
Beyond the scope.
Overruled.
Yes.
And in your entire career as a criminalist, can you ever recall an occasion where you did that,
I've never done that.
where you've conducted a what you would consider a witness interview?
That's correct.
But you have made inquiries of detectives?
Yes.
Sir, you were asked some questions regarding the scoop method that you demonstrated on item number 10. Why did you use the scoop method on the witness stand for the purposes of repackaging it?
The question came up whether it could be used or not, and I used it.
Now, sir, when you looked at the seals on that item on the witness stand when Mr. Scheck showed it to you this afternoon, or this morning rather, was there a red and yellow seal? Was there a yellow seal on it?
There were yellow seals on it.
And is there a significance in LAPD to a yellow seal as opposed to a red seal?
Yes.
What is that?
A red seal is used by the person booking the evidence, and the yellow seal is used by the analyst who performs some type of examination on the evidence.
So the yellow seal indicates that it was in fact examined.
Yes.
And did you notice anything on the envelope or on the item itself which indicated that?
Yes.
What?
There were several initials on different portions of the plastic bag.
Okay, now, sir, I want to ask you about the condition of that item when you first opened it up on the witness stand and saw it. And distinguishing between the word crumpled, as in an item that's folded in on itself and kind of bunched together, and wrinkled, meaning an item that may be folded but has creases that are apparent in it. Was this, I think,
Calls for speculation, maybe.
Well, this is not a big deal. I'll allow the question. The jurors have seen the item. They saw how it came out. They saw how it went back in. They saw how it came out. They saw how it went back in. and they've seen the photograph of it at the crime scene.
Okay. When you brought it out for the first time on the witness stand, was it crumpled?
No.
Was it wrinkled, as I've just used that term or defined it?
There were wrinkles in it.
Okay, but was it folded?
Yes.
Okay. Your Honor, I'd like to read a portion from the from the trial transcript at page 22,971. A
Right.
portion of which was just read in and recrossed.
All right, give Mr. Schick.
That's 22,971, starting at line 19, to 22,972, ending on line 25. Sir, at the trial, do you recall giving the following answers to the following questions? Question, Mr. Fung, do you have an independent recollection, as you sit here today, of placing the item that you received from Detective Van Adder, the envelope, into the plastic bag? Answer, not an independent recollection, no. Question, okay. And when you looked at the scene of Andrea Mazzola taking the plastic bag out of the location, was there anything that you collected between 5 o'clock and when you left with Andrea Mazzola that could have accounted for the heft in that bag other than the envelope? Answer, possibly, but it's most likely that the envelope was in that bag. Question, okay. Question, did you collect anything between 5 o'clock and the time that Ms. Mazzola and yourself left with the plastic bag that was the same approximate size and dimension of the analyzed envelope? 163. Answer, was there anything? Question, the one in front of you. Answer, was there anything else that we collected that was this size? Question, yes. Answer, is that what you are asking? Question, yes. Answer, no. Question, did you have any other envelopes that were that size? Answer, no. Do you recall giving those answers to that question?
Yes.
Now, as to the yes.
Thank you, counsel.
Now, sir, you were asked a number of questions about whether you've ever received any pressure from anyone from the DA's office to change your testimony in any way. Have you?
Change my answers?
Yes.
No.
And from anyone else, the crime lab or even disinterested parties?
No.
Now, sir, did you ever even consider the possibility of testifying that as to the rear gate stain, that you saw it on June the 13th?
Grounds.
I think this is, my apologies, let me hear the whole question.
That was the whole question.
Proceed.
I never considered changing my answer that I had ever seen the stain on June 13th.
Okay. And you were asked about mistakes, sir, and your willingness to own up to mistakes. If you could do something differently at the crime scene, would you like to have collected that stain on the 13th?
Yes.
He misstates the testimony. His testimony assumes a
Sustained.
fact beyond this witness's
Sustained.
comments.
Rephrase the question.
Okay. Would have you liked to have inspected the gate more carefully?
Yes.
And, sir, did you ever consider changing your testimony or testifying that as you sat there on this witness stand, that you had an independent recollection about putting the item that you received from Detective Van Adder into the bag, the plastic bag?
I don't understand your question.
Okay. Did you ever consider testifying, sir, that you could remember from your own independent recollection putting the analyzed evidence envelope containing the blood into the plastic bag?
No.
Did you ever consider, sir, testifying that you looked at the socks, item number 13, carefully enough and saw blood on them?
No.
And did you ever consider testifying, sir, that you looked at the Bronco on June the 13th and saw red stains other than the one on the handle?
No.
Sir, when you were being cross-examined by Mr. Scheck, did you ever have difficulty understanding what he was getting at in his questions?
Sometimes.
And
Oh.
And when you were being cross-examined, sir, did you, how did it make you feel when you were sort of being yelled at in an accusatory?
I would object and
Sustained.
choose to strike.
Sustained. And if we have any more reaction from the audience, I'm going to clear the audience.
Was there anything in the way that you were questioned, sir, that made it more difficult for you to understand the questions?
Yes.
And what was that?
It was a aggressive questioning style.
Okay. Did you find it easier to answer his questions this morning?
Yes.
Why?
He was much less aggressive this morning.
Do you consider being accused of engaging in a cover-up less aggressive?
It was the manner, not the content.
Okay. Now, sir, do you remember everything that you did, all of your activities on June the 13th of 1994?
No.
All right. Do you remember every conversation that you had with the detectives on June the 13th of 1994,
No.
or with other people?
No.
Do you remember all of the testimony that you gave over the last 8 days during the direct cross examinations?
It's all a blur.
Well, do you remember the question when you were shown the picture of the rear gate and Mr. Scheck said, "Where is it, Mr. Fung?"
I remember that.
Your Honor.
I was just curious. Thank you. Thank you, Mr. Fung. Nothing further. Thank you.
Mr. Scheck.
Can we approach for just 1 minute before I start?
Sure.
this?
Thank you, counsel. Proceed.
Just a few questions, sir. Mr. Fung, it's easier to testify on direct examination than cross-examination.
Yes, it is.
And you've been a witness a number of times in different cases.
Yes.
And it's always more difficult to testify on cross-examination than direct examination.
Yes.
And would you not agree, sir, that some of the difficulties you had answering the questions on cross-examination during this trial had to do with the facts?
I don't.
Sustain.
Had to do with reports that you wrote.
In what regard?
Contradictions in the between your testimony and reports you wrote.
I was prepared for the type of questions that Mr. Goldberg would ask, and the questions that you asked were surprise questions to me. So, of course, they would be more difficult for me to answer.
Yes, and when you viewed some of the videotape, that surprised you too.
Yes, some of it did.
And when you were testifying about a number of events for which you didn't have an independent recollection, but you were going along with suggestions of testimony on direct, that was a problem too.
Sustain. Sustain.
Did you ever have a problem when you were testifying because you were testifying to facts that you really didn't have an independent recollection about?
Overruled.
I tried the best I could to be truthful in my answers and honest.
Now, Mr. Goldberg asked you about pressure from the district attorney's office,
Yes.
and your position is you never felt any pressure from them to testify in a certain way.
They never gave me any pressure to change my answers.
Well, did they make strong suggestions to you about what your answers should be?
No.
Overruled.
Have you ever spent 10 sessions, some of them as long as 5 hours, reviewing your testimony before you testify?
Never.
And could it be, sir, that in those sessions, as you reviewed all these facts and tried to get your testimony in a way that would please the prosecutors?
I haven't heard the full question, but it sounds like it's going to be
All
calling for
right.
speculation.
In these 10 sessions, you made your best efforts to work out testimony that the prosecutors would find satisfactory.
Much of the testimony was my educating Mr. Goldberg as to our procedures and different type of circumstances that we undergo out at crime scenes.
Well, in the course of your preparation, were other people from the lab involved?
At certain portions, yes.
Michelle Kessler?
She was never present when I was speaking with Mr. Goldberg.
To your knowledge, did she have input with respect to your testimony as far as you knew?
Sustain.
She ever discussed your testimony with you before you came here?
Overruled.
She gave me pep talks and things like that, but we never discussed specifics.
What about Detective Lang?
I did have discussions with him.
All right. Detective Van Adder?
Yes.
Now, I noticed that Mr. Goldberg didn't ask you whether or not you'd felt any pressure from the detectives.
Sustain.
Well,
Rephrase the question.
Did you feel any pressure from the detectives to testify in a certain way?
No pressure, no.
Was there anything about my accent that made it hard for you to answer my questions?
Not your accent, no.
Oh, okay. Was there anything about the substance of the questions that you were being asked that made it difficult, sir?
Vague. Sustained.
Now, you said that on this redirect, that it didn't make the slightest bit of difference as to whether or not you collected the socks between 4:30 and 4:40.
Not in my mind.
Well, then, why, pray tell, did you change your testimony from direct and cross about when you could have collected the socks?
Sustained. Rephrase the question.
Why, sir, did you change your testimony from what you'd stated on direct and cross-examination about the time frame when you could have collected the socks?
Overruled.
I believe that in one one question, one of the questions was I sure I had collected the evidence from one point or another, and I wasn't 100% sure which item I had collected prior to the other.
Well, on direct and cross, you indicated that you were sure.
Sustained. Rephrase the question.
Well, you answered questions about the order of collection and when you collected on direct and cross.
Yes.
And on redirect, Mr. Goldberg asked you a number of times, or twice, I should say, if you were really sure that the collection of socks happened within that period.
Overruled.
He was referring to specific times within that time frame.
Well, did you, before you came here for redirect examination, say to Mr. Goldberg, I've been thinking about it, and I may be wrong about how the time the socks were collected. Could you please raise that again on redirect? Is that what happened?
No.
It was his idea.
Sustained.
It was his request of you to think about the time of collection again.
Sustained.
Before you came and testified on redirect, did you have discussions with Mr. Goldberg or other prosecutors about whether you were really sure concerning the time you collected the socks?
It's just vague as to whether he means, he has to bracket it. He doesn't have the first time.
Overruled. You can answer the question.
We have discussed the time frame of the socks, but as to the second time he asked me in recross about the socks, I don't recall discussing it prior to him asking recross
No.
socks questions.
Mr. Fung, redirect. Remember that?
Redirect.
Sustained. Come on.
Mr. Fung, direct your attention to the redirect examination.
Yes.
On redirect examination, you now said that you weren't really sure.
Yes.
And the suggestion, withdrawn, the issue of whether you were really sure was raised by the prosecutors.
Well, it's vague as to in court or out of court.
Overruled. We're talking about redirect.
Yes.
Yes.
And that was prior to those questions being asked of you.
Well, now it's vague.
That's true.
All right? That was prior to the time that you testified on redirect.
Yes.
Okay. And after they asked you if you were really sure, you told them before you got on the stand, well, I'm not that sure.
I wasn't that sure. No.
Well, maybe he's not answering the question. Motion to strike.
Overruled.
And you became unsure because you thought that's what they wanted to hear.
No, I became unsure because he was asking for a specific time within that time frame, and I just wasn't sure.
Mr. Fung, on direct examination, you were asked about the time frame between 4:30 and 4:40. You collected the socks. Right?
Yes.
His question on redirect was, could you have corrected the socks sometime different than between 4:30 and 4:40, right?
On redirect.
Yes.
Yes, he asked that.
And that's what you that's what you testified you were no longer sure about.
Yes.
And you now began testifying on redirect that you were no longer so sure of the order.
Yes.
And that's because the prosecutors wanted you to be unsure about the time and about the order.
That's not true.
No further questions.
Just briefly. Yeah, let's see if we can get this, Mr. Fung. Now, when we were discussing, before you ever came into this courtroom to testify, about the order in which things were collected, did you tell me that the order was 12, 13, and 14?
Yes.
Okay. Now, on redirect.
Redirect, okay.
No, actually, it was redirect. I'm sorry. Okay, now on redirect, did you testify that you weren't sure whether 13 was collected before 14?
I stated I didn't know, or I don't know what I stated at this point. I was unsure at that point.
Okay, now what Mr. Scheck was asking you is, was there a conversation that we ever had between the time that you were finished on cross-examination, okay?
Yes.
And the time that you said that you weren't sure on redirect, was there ever a time when you told me you weren't sure?
No.
Okay, and was there ever a time that you can recall between those two times that we discussed the issue?
Not that I recall.
All right. And Mr. Fung, have you ever testified before in a case where you were on the witness stand for 8 days?
Never.
Are you going to be glad to be off?
Very.
Okay, thank you. Nothing further. Thank you.
All right, Mr. Fung, I'm going to excuse you from further testimony in this case. At this time, you're still subject to recall, however. Please don't discuss your testimony with anybody other than the lawyers. All right, you're free to go. Thank you, sir.
Thank you.
All right, ladies and gentlemen of the jury, I'm going to need to shift gears here momentarily. I'm going to ask you to step back into the jury room. Please remember all my admonitions to you, and we'll be talking with you shortly. All right? Package of reports regarding apparently hair comparisons from the FBI lab. One counsel approach from each side, and I'll give you a copy of the reports. Yes. All right, over the lunch hour, counsel proposed to the court a procedure to go forward with the inquiry that the court has indicated that is going to make regarding jury issues. Either side wish to be heard as to the presence of the defendant issue and the manner in which the inquiry should be conducted.
Yes, I'd like to be heard just briefly, Your Honor, if I might. Certainly, we do endorse the going ahead with the jury process now, Your Honor, and doing it in a continuous manner. I think it'll be better for all parties, and I think in this regard, both the prosecution and the defense agree. The court had been kind enough in a brief conference to mention to counsel the People versus Siripongs case, Siripongs, a 1988 case. Although I have not had a chance to get the case, I do, in fact, had a chance, of course, to look at the California Criminal Law Procedure and Practice, second edition,
Which is where I
which
found
the
the
court
Siripongs case.
had suggested to us. And in that case, as the court is aware, there is a statement in the second paragraph under Section 3324 that counsel and the defendant should be present at the hearing. And it goes on to indicate that in some circumstances, however, counsel may be excluded from the hearing as long as he or she is given a transcript of it. It cites People versus Siripongs. And under that paren, it says, defense attorney excluded at defendant's request, no constitutional violation. In this instance, what we're asking the court to do, given where we are at this point in the proceedings, after having been in trial in this matter since, I guess, September 26th, and being the 12th week or so of actual testimony, that Mr. Simpson be allowed to be present during this jury inquiry. That's all we're really asking, Your Honor. We don't think it poses any kind of security problem. We don't think there would be any effect upon the jurors as the court inquires upon them. We do not anticipate, from the defense standpoint, of asking the court to cross-examine any particular juror. In fact, without going into the procedure that we've used in the past, I would just indicate to the court that we expect to do as we've done in the past. And I think that Mr. Simpson has no objection to that. And the court has previously ruled that as regards previous jurors or non-jurors at this point, the defendant has been present. And I just think that where he does not wish to waive his being present, that the court should allow him to be present. I think that if the Siripong case, I guess, stands for anything, counsel can be excluded, but it doesn't say the defendant can be excluded. And I don't plan to waive my presence at this point either, Your Honor. Perhaps I think the court has set some rules regarding the number of attorneys, and we have no problem with that. I think the court has said that you may limit the number of attorneys who may be present during these proceedings. But I just think that we can get on with this and get it done in a timely and appropriate fashion. It's been conducted quite well before. I just think this is not a matter that for a public hearing, but I think that the defendant, who has the most to lose in this entire thing, is entitled to a fair trial, and it certainly would impinge upon his constitutional rights to be present if we have to then go back and try to translate for him what took place at these hearings. And that's how I think we really got to this point, Your Honor. So I'd respectfully ask the court to set up a procedure that the court feels is appropriate, whereby he can be present during these hearings, and we'll conduct it in the same way as we've done the other hearings back in chambers. Thank you, Your Honor.
All right. People?
Yes, Your Honor, I read the case law submitted by the defense, People v. Garcia. The problem with that case law that they have submitted is that there is nothing in which it is stated explicitly that the defendant has an independent right to be present. The case really addresses the issue as to whether or not the court should properly address jury issues outside the presence of any of the lawyers or the defendant. And it says that, no, the defense has the right to be represented at such a hearing or at any contact with the jury that the judge may have, but it did not specify that it had to include the defendant. Nor have any of the cases we have found indicated that there is any such right. And to the contrary, as the court has pointed out, People v. Siripongi, also People v. Medina, 51 Cal 3rd 870, and People v. Freeman, 8 Cal 4th 450, both of which do address the defendant's right to be present at various chambers conferences, make clear that the defendant does not always have the right to be present at every chambers conference or chambers issue. With respect to these issues, they are of such a confidential nature that they do need to be conducted in chambers, which poses a very obvious problem with respect to having the defendant present. And there are also concerns with the ability of the jurors to be as forthright as they possibly can. The more we create an open hearing in which there will be many people present and many the more people in the audience and the bigger the setting in terms of having to be in the courtroom, I think the more of a chilling effect we produce on the jurors, and the less encouraged they are to be completely candid with us about what is going on. So in order to encourage candor, in order to encourage the kind of openness that will allow the court to make a thorough and fair investigation, I think that it is in the best interest in a search for the truth and a fair trial to have this in chambers.
I would just, and I neglected to mention this before, I think also that Penal Code Section 1120 is somewhat instructive when it talks about where it requires a juror, quote, must be sworn as a witness and examined in the presence of the parties. And again, I always come back to the fact that Mr. Simpson is the party here. That statute was subsequently amended in 1965. I think the reason why we cited to the court the People v. Garcia case, the 1984 case, holding that a defendant's right to be present protected by the fundamental constitutional right to the assistance of counsel at all critical stages of the proceeding. If one takes that, Your Honor, this is a critical stage of the proceeding because what the court finds out here is very important, I think, to all of us. And I think that's why the court is doing this now. I think, in response to what Ms. Clark has said, that I don't think it's chilling at all with the defendant present. It doesn't make it, if the court has a certain number of counsel on each side, and the defendant is not going to make the jurors less candid because Mr. Simpson is here. After all, this case is about the people versus O.J. Simpson. And I'm reminded of the time when we first started picking the jury in this matter. The court will recall we were up on the 11th floor. And we were in a little tiny room, if the court will recall, when we first started screening jurors. And Mr. Simpson was at the table. In fact, Ms. Clark and I sat side by side, and Mr. Simpson was down at one end. The jurors sat at one end, and the court will recall that, and the bailiffs were all there. And I think the people were very candid right from the beginning. That's how this court has conducted this matter at times at critical stages of the proceeding where Mr. Simpson should be present. That's all we're saying, that why err in this regard? I think that this is a time he has a right to be present. It poses no security problems, and I think that I'm not suggesting we put the jurors on the witness stand, but wherever they feel comfortable. We can close it in or however you want to do it, as we've done in the past. I think that this is somewhat unique, and what's happened is there is a dearth of legal opinions in this regard because you'll have to search far and wide before you'll find this kind of proceeding where we're this far into trial, where we have an issue like this arising regarding jurors, where we have to go and talk to all the jurors. So there's not a lot of cases. As we have proven so many times, Your Honor, it's this particular case that has caused a lot of issues that people haven't dealt with in the past. What I found is that when you have something unique, it does require us to be careful. It does require us to keep in mind why we're here. It does require us to protect all of the rights. And all we're asking you to do is to protect Mr. Simpson's rights in that regard. And I think that 1120, Garcia, even Siripongi, I mean, I think that it doesn't say that the defendant can't be present. It talks about the lawyer being waived. So I think that where he wants to be present, I think he has a right to be present. And I think the reasons for him not being present are not persuasive. And I would ask the court to consider this, and let's move on and let's try and resolve this matter in the course of the next day or so. Thank you, Your Honor.
All right, thank you, counsel.
I'm sorry, I don't want to, I just want to straighten out one misconception that perhaps has been created. I don't feel necessarily that Mr. Simpson's presence is going to have a chilling effect. I feel that the setting that we will be forced to be in and the number of people that will be forced to be present will be the problem and produce the more chilling effect. It's clear that when we have a more intimate setting where there are fewer people, that we can expect a little more candor and the jurors will feel more secure and more calm. And that's what we want to encourage. And that was my point, Your Honor. And moreover, the case law makes it very clear that the defendant is entitled to be represented, and he has very able representation, and his lawyers will fight very vigorously in his behalf, as they always have, and they will continue to do. And his rights will be fully protected by their presence in chambers at any conference that may be conducted. And I think that that's what the court has to look at in terms of what is required, and that will certainly be observed by this court.
All right, thank you, counsel. All right, I don't find Penal Code Section 1120 to be controlling in this particular issue. And the 1988 California Supreme Court opinion, People v. Siripongs at 45 Cal 3rd, 548, and specifically the text that begins at page 570, and the discussion on 571 and 572 does directly address this issue. The matter will be addressed by the court in chambers out of the presence of the defendant. All right, we'll take a 20-minute recess, and we'll start with the inquiry. All right. And let me ask Ms. Clark, as far as we have 18 jurors to talk to, my guess is we'll be at this most of, certainly the balance of today and probably the balance of tomorrow, is my guess, since we have 18 people to talk to, perhaps 20 minutes, 30 minutes apiece, depending on where it leads us.
I really think that's a fair estimate.
All right, then my guess is that as far as the presentation of testimony and Ms. Mazzola is concerned, we probably ought to then stand in recess, today being the 18th, until the 20th.
Resume with testimony on 20.
All right, does that cause any scheduling problems?
I mean, the lawyers should be counting the next witness. It will not cause a scheduling problem.
All right, this was your suggestion, Mr. Cochran.
I'm not cross-examining Mr. Goldman. No problem.
All right, then as far as the presentation of evidence is concerned, then we'll stand in recess until the 9 a.m., April 20. All right, thank you, counsel. Yes? No. Tell me about it. All right, thank you, counsel.